Money laundering is the practice of receiving illegally acquired funds and then passing them off as money obtained from legal sources. Individuals or companies engaging in money laundering may seek to transfer these unlawfully obtained funds to different parts of the globe using money remittance centers, banks, and their digital payment systems. The Anti-Money Laundering Act or AMLA of 2001 or RA 9160 criminalizes unlawful activities such as graft and corrupt practices, fraudulent practices, robbery and extortion, swindling and plunder, amongst other activities. Under Amla Law, unlawful activities are acts or omissions involving or having relation to any of the 36, previously 34 crimes listed under Section 3 of the Amla Law. Money laundering is committed when a person transacts, converts, conceals, attempts, abets, among others, any monetary instrument or property, knowing that it relates to the proceeds of an unlawful activity. Furthermore, covered persons are required to report suspicious transactions to the AMLC regardless of the amount involved, and one such suspicious transaction is when it relates to an unlawful activity. Money laundering is likewise committed when covered persons fail to report covered or suspicious transactions.
Under the Anti-Money Laundering Act, transaction refers to any act establishing any right or obligation or giving rise to any contractual or legal relationship between the parties thereto. It also includes any movement of funds by any means with a covered institution. Covered transaction refers to: first, a transaction in cash or other equivalent monetary instrument exceeding 500,000 pesos. Second, a transaction with or involving jewelry dealers, dealers in precious metals, and dealers in precious stones in cash or other equivalent monetary instrument exceeding 1 million pesos. Third, a casino cash transaction exceeding 5 million pesos or its equivalent in other currency. Covered transaction is a transaction in cash or other equivalent monetary instrument involving a total amount in excess of 500,000 pesos within one banking day. Covered transaction or CDR are reports in a covered transaction as filed by a covered person as discussed in a previous article. Money laundering and terrorism financing investigator is one of the powers and functions of the Anti-Money Laundering Council. As financial investigator, the AMLC shall investigate, among other things, suspicious transaction and covered transaction deemed suspicious after the investigation by the AMLC. Suspicious transaction refers to a transaction regardless of amount where any of the suspicious circumstances, as therein defined, is determined based on suspicion or, if available, reasonable grounds to be existing. The law says suspicious transaction is a transaction regardless of amount where any of the following circumstances exist. First, there is no underlying legal or trade obligation, purpose, or economic justification. Second, the client is not properly identified. Third, the amount involved is not commensurate with the business or financial capacity of the client. Fourth, taking into account all known circumstances, it may be perceived that the client's transaction is structured in order to avoid being the subject of reporting requirements under the Act. Fifth, any circumstances relating to the transaction which is observed to deviate from the profile of the client and or the client's past transaction with the covered institution. Sixth, the transaction is any way related to an unlawful activity or any money laundering activities or offense under the AMLA as amended has been committed. 7. Any transaction that is similar, analogous, or identical to any of the foregoing.
Covered institutions or persons. Covered institutions was changed to covered persons under Republic Act No. 10-365. Covered persons are natural or juridical and shall register with the Anti-Money Laundering Council. Notwithstanding the foregoing, the term covered persons shall exclude lawyers and accountants acting as independent legal professionals in relation to information concerning their clients or where disclosure of information would compromise client confidences or the attorney-client relationship, provided that these lawyers and accountants are authorized to practice in the Philippines and shall continue to be subject to the provisions of their respective codes of conduct and professional responsibility or any of its amendments. Covered persons refer to 1. Banks, non-banks, quasi-banks, trust entities, foreign exchange dealers, pawn shops, money changers, remittance and transfer companies, and other similar entities and all other persons and their subsidiaries and affiliates supervised or regulated by the Bangko Sentral ng Pilipinas. 2. Insurance companies, pre-need companies, and all other persons supervised or regulated by the Insurance Commission. 3. In securities dealers, brokers, salesmen, investment houses, and other similar persons managing securities or rendering services as investment agent, advisor, or consultant.
Suspicious transactions are transactions with covered institutions, regardless of the amount involved, where any of the following circumstances exist. First, there is no underlying legal or trade obligation, purpose, or economic justification. Second, the client is not properly identified. Third, the amount involved is not commensurate with the business and financial capacity of the client. Fourth, taking into account all known circumstances, it may be perceived that the client's transaction is structured to avoid being the subject of reporting requirements under this Act. Fifth, any circumstances relating to the transaction which is observed to deviate from the profile of the clients and or the client's past transactions with the covered institution. Sixth, the transaction is anyway related to an unlawful activity or offense under this Act that is about to be, is being, or has been committed to. And lastly, any transaction that is similar or analogous to the foregoing.
Said records and files shall contain the full and true identity of the owners or holders of the accounts involved in the covered transactions and all other customers' identification documents. Covered institutions shall undertake the necessary adequate security measures to ensure the confidentiality of such file. Covered institutions shall prepare and maintain documentation in accordance with the aforementioned client identification requirements under customers' accounts, relationship, and transactions such as any account, relationship, or transaction can be so reconstructed as to enable the AMLC and or the courts to establish an audit trail for money laundering.
Record-keeping requirements, kinds of records and period for retention, existing and new accounts and new transactions and closed accounts shall be maintained and safely stored for 5 years. Retention of records in case a money laundering case has been filed in court, retained beyond the period stipulated in the 3 years immediately preceding sub-rules as the case. Form of records. Records shall be retained as originals in such forms as are admissible in court.
AMLC has the power to formulate and implement such measures as may be necessary and justified under the AMLA and TFPSA to counteract money laundering and terrorist financing, or MLTF. The AMLC can enlist the assistance of any branch, department, bureau, office, agency, or instrumentally of the government in undertaking any and all money laundering and counter-terrorist financing. AML CTF operations. The MLC may enlist the relevant SAs, LEAs, and OGAs to assist in domestic coordination and cooperation efforts to counteract MLTF. The AMLC shall receive and take action in respect of any request from foreign states for assistance in their own AML-CTF operations as provided in the AMLA. The AMLC has been asked to develop an AML-CTF training system for public and private stakeholders, especially for financial intelligence, investigation, and legal personnel on the fundamentals of MLTF. The AMLC shall conduct tactical analysis which uses available and obtainable information to identify specific targets.
Reporting requirements. The Anti-Money Laundering Council recently approved registration and reporting guidelines. The four-part EMLC provides the legal and policy framework for covered persons to register in the online system and ensures proper and timely reporting. The approved registration and reporting guidelines consolidated already EMLC resolutions, including Resolution Number 180, Series of 2004, Implementation of the File Transfer and Reporting Facility, and Resolution Number 117, Series of 2009, Adoption of Single Institutional Fee for the EMLC Secretariat and Implementation. The Anti-Money Laundering Act of 2001 as amended and the 2016 revised implementing rules require covered persons such as banks, insurance companies, and securities dealers to file STRS within 5 days of the suspicious transactions experience, which should not exceed 10 calendar days.
If the circumstances of filing an STR have no corresponding transaction, or if transaction monitoring system generated alerts are only grounds for the covered person to conduct an internal analysis, investigation, and escalation, the suspicious nature of the circumstances shall be determined within 60 calendar days. Two new facilities will now allow covered person to upload Know Your Customer documents for STRs and e-returns via the AMLC portal. If the reason for suspicious is based on the predicate crimes of kidnapping for ransom, drug trafficking, hijacking, destructive arson, and murder, including those perpetrated by terrorists against non-combatant persons and similar targets, and acts of terrorism and terrorism financing, the upload of KYC documents should be done before the STR is uploaded. According to the Executive Director Mel Georgie B. Rosella of the AMLC Secretariat, the ARRG is a significant step toward improving the quality and usefulness of information and reports submitted by covered persons. The imposition of appropriate sanctions after observance of due process will ensure a culture of compliance among them. Rosella said the AMLC had long wanted a revamp of the system and rules on registration and reporting due to the surge in the number of covered persons, and thus of their transactions. Moreover, the quality of SDRs had to be improved. The AMLC had also striven to find suitable ways to establish a central linkage among the supervising authorities that would facilitate our coordination. Finally, the adoption of the ARRG should strengthen the tools available for the AMLC in its fights against money laundering and terrorism financing.